अलैहि या रसूलल्लाह वस्सलाम अलैहि या हबीब अल्लाह। प्यारे व्यूवर्स, उम्मीद करता हूँ तमाम दोस्त खैरियत से होंगे और अल्लाह ताला आप लोगों को सेहत के साथ लंबी ज़िंदगी अता फरमाए और इज़्ज़त वाली ज़िंदगी अता फरमाए। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक बआसानी पहुँच सके। आइए चलते हैं अपनी सीरीज़, आगाज़ करते हैं नंबर 23 से, पावर्स ऑफ हाई कोर्ट। High Court has no power to interfere with the police investigation and assume the role of investigator. Conduct and manner of investigation is not to be scrutinized under constitutional jurisdiction which might amount to interference in police investigation, as the same cannot be substituted by the कोड PLD 2003 KAR 209। Number 24, cancellation of FIR by session judge. Session judge has no jurisdiction to entertain a miscellaneous application submitted by the mother of the accused person whose case was pending trial before magistrate, and then to pass order against an order passed by a magistrate refusing to discharge accused person or to cancel FIR. Such an order is only an administrative order and not a judicial order amenable to revisional jurisdiction 2003 by 245। Number 25, telegraphic message. Police reaching spot may collect details of incident and treat the same as FIR PLJ 2001 SC AJ and K 160। Number 26, provision mandatory. Provisions of section 154 CRPC are mandatory in nature. Police officers to register FIR violation would expose him to prosecution under section 166 PPC 2003 YLR 1316 2004 YLR 2599। Number 27, refusal to register FIR remedy. On refusal of the police to register FIR in a cognizable case, the adequate remedies available to the agreed parties are firstly by approaching the session judge ex officio justice of peace for exercise of power under section 22A. Under 6 CRPC, secondly by approaching the magistrate for exercise of power under section 156 under 3 CRPC, and lastly by filing a direct complaint under section 200 CRPC, invoking of writ jurisdiction in the presence of adequate remedy by being available is not desire of law 2004 YLR 2599 PLD 2001 KAR 269 PLD 1999 LAH 417 2003 YLR 550 REF। Remedy under Article 199 of the Constitution can be exercised only on proof of non-availability of adequate remedy। PLD 1987 SC 21 1987 SCMR 810। Supreme Court directed Inspector General of Police to take strict disciplinary action against officials who are responsible for not registering the case after happening of the incident 2006 SCMR 1547। Number 27, principle of double jeopardy not applicable 2004 MLD 1201. It is not necessary for complainant to be an eyewitness of occurrence. Law could be set at motion by any person 2086 MR 1786. Section 155. Information and cognizable cases. When information is given to an officer in charge of police station of the commission within the limits of such station of a non-cognizable offence, he shall enter in a book to be kept as aforesaid the substance of such information and refer the information to the magistrate. Number 2. Investigation into non-cognizable cases. No police officer shall investigate a non-cognizable case without the order of magistrate. Of the first or second class, having power to try such case for send the same for trial to the court of session. Number 3, any police officer receiving such order may exercise the same powers in respect of the investigation except the powers to arrest without warrant as an officer in charge of a police station may exercise in a cognizable case. Number 2, cognizable and non-cognizable offences. Where a case is registered against accused relating to facts entailing commission of both cognizable and non-cognizable offences, provisions of section 155 under 2 would not attract and police could investigate such a case without permission of the magistrate 2004 PCR LJ 387. Section 156. Investigation into cognizable case. Any officer in charge of a police station may, without the order of magistrate investigate any cognizable case which could have jurisdiction over the local area within the limits of such a station would have power to inquire into or try under the provisions of chapter XV relating to the place of inquiry or trial. Number 2, no proceedings of a police officer in any such case shall at any stage be called in question on the ground that the case was one which such officer was not empowered under this section to investigate. Number 3, any magistrate empowered under section 190 may order such an investigation as above mentioned. Number 4, notwithstanding anything contained in subsection under 1, under 2 or under 3, no police officer shall investigate an offence under section 497 or section 498 of the Pakistan Penal Code except upon a complaint made by the husband of the woman or in his absence by some person who had the care of such woman on his behalf at the time when such offence was committed. आखिर में मैं अपने तमाम दोस्तों का शुक्रिया अदा करता हूँ और गुजारिश करता हूँ कि मेरी वीडियो को शुरू से लेकर आखिर तक देखें ताकि आप मुकम्मल तौर पर कानून से आगाही हासिल कर सकें। दरमियान में मत छोड़ें वीडियो को, पूरी वीडियो देखा करें ताकि कानून को समझ सकें। तो मेरी आप तमाम दोस्तों से रिक्वेस्ट है कि मेरे इस चैनल को सब्सक्राइब भी कर लें, घंटी और लाइक के बटन को भी दबा दें ताकि हर नई आने वाली वीडियो आप तक पहुंच सके। अल्लाह हाफिज़।